At BWF Solicitors, we take pride in our client service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Hello, ladies and gentlemen. You are welcome to Heritage TV, hanging out with Vicky. I must sincerely apologize for the long delay in a transmission coming, live to you. I really appreciate your absence. I was receiving so many phone calls, messages, people patiently waiting to, find out the reason why we haven't been on as schedule. What I'll say is that it's for a good cause, and thank God we are here now. Thank you so much for your patience once again, and staying with us. Today we're going to discuss leave to remain based on private life, and as usual, we have our in-house solicitor and partner of BWF Solicitors, lawyer Achampong. You might ask yourself, what is private life? And you also ask yourself, what are the requirements? Who is entitled to be given leave to remain based on private life? Our lawyer will give you the explanation and tell you who qualifies and who doesn't qualify, and what it really means to, be given leave to remain based on private life. She's going to explain everything to us. If you want to contribute to the program or ask a question, please send me a message on Facebook, YouTube, and all social media handles at Heritage TV. If you want to also contact us live in the studio, our numbers are 0203 9833 The number again is 0203 9833 or 0330 1139498. Right. So I'm gonna quickly introduce our in-house lawyer from BWF Solicitors, lawyer Eunice Achampong. Hello, lawyer Eunice.
Hello, Vicky. How's your week been?
It's not been bad. Just that this morning has been a bit stressful trying to get on air on time. But like I was telling our viewers, it's for a good cause. At the end of the day, we've managed to come live on air. Yeah. And I also have to thank you so much for your patience as well.
Oh, that's fine. Don't worry about it. I mean, these things happen, so we always have to keep it in mind and just adjust.
Exactly.
Yeah.
Lawyer Eunice, yes, we've come again with another interesting and popular topic, which is leave to remain based on leave. One will ask, what is long residence application or leave to remain application based on family life?
So usually this kind of application is one which a lot of people who may not necessarily be married, may not necessarily have children in the UK, they are the ones that would want to find out more about applications such as this. So if they've lived here for a period of time, they haven't formed any family life, and they still want to make an application, they will be making an application on private life. And somebody will ask, what is private life? Under our Human Rights Act and the European Convention on Human Rights, we have different rights for our, should I say, our living as human beings. So you have freedom from torture, freedom or right to education, right to healthcare, and so many different rights that come under the European Convention of Human Rights. And one of those rights is the right to a family life and to private life. This right is under Article 8. It's not an absolute right. So that means that the state or the country in which you're living in can in some way interfere with that right because it's not absolute. And so in this case, if you are making an application, the state or the government in which is, should I say, ruling the day would have to assess your right to private life and see whether that right will interfere with something that they call public interest. And if it doesn't, then you will be granted leave to remain based on your private life. And under our immigration rules, we have a paragraph called paragraph 276 ADE. And that paragraph basically states can apply for application for leave to remain, and the III make an application saying that they have lived here continuously for a period of 20 years. And this should discount any period that they have spent in prison. So usually if you are somebody who has been in this country for a period of 20 years, they will say that you have formed private life. Somebody will say, why not 10 years? Why 20 years? And like I said, there's not an absolute right. So the government has any, should I say, they can make up any reason as to why they can interfere with that right. And so for them, they have said it is 20 years. Previously, most people would have known that if you have lived here for 14 years, you make an application before 2012. When you make an application, you'll be granted indefinite leave to remain in the UK. Even though you have lived here illegally, you would make the application, and or as soon as you provide evidence that you have stayed here, they would grant you indefinite leave to remain. And so people still have that in mind. People still think if illegally for a period of, let's say, 14 years, and if now it's 20 years, they should still grant me indefinite leave to remain. But unfortunately, since July 2012, when the Conservative came in with the coalition government, Lib Dems, they restructured the immigration rules and made it so that if you've lived here continuously for a period of 20 years, you would be able to apply for limited leave to remain, which is a period of 30 months. And that's what we usually call 2.5 years leave to remain. So if you have lived here continuously for a period of 20 years, they will give you leave to remain on the 10-year route. So it is not possible to given leave to remain on the 5-year route. It is only on the 10-year route. And once you are given 2.5 the 10-year route, you would have to complete a period of 10 years before you can apply for indefinite leave to remain. So it is totally different from what people used to know before 2012. And now you have to be on that route until your 10 years is basically up. And that's the unfortunate thing, but that's what it has now come to. In
Okay.
this day and era, I think there are a lot of people who are thinking, so doesn't mean I have to here for 20 years before I can make this application. And the truth of the matter is, yes, you would have to have lived there for at least 20 years before you can make this application based on private life. Yeah.
Okay, great. So, what is the caseworker looking out for when, aside proving that you've been in the country for 20 years, what are some of the requirements? Is it do you have to be of good character? Would they request for pay slips, bank statements? The reason why I'm asking this question is most people who have overstayed
Mm,
and have been in the country for almost 20 years, definitely
mm,
most of them, I'm assuming, might not have access to their own bank accounts or have access to, uh, doing, proper jobs, if I should say, in
mm,
quotes. So, how are you going to prove what are documents required to ascertain your eligibility to apply for the leave to remain based on private life? That's living here for 20
okay.
years.
Okay. So as I was saying,
Mm,
under paragraph 276 ADE 1, you have to have made a valid application. That is, you should have made an application using the right form. Usually, most people would use form FLRFP to make the
mm,
application, and it's an online
mm,
application. And all basically saying that you can provide a valid form of identification. You would have a passport. So whichever country you're from, you should have some form of valid passport to show your nationality,
mm,
and indeed that you are a national of that country. And usually, with all our applications, you would have to provide some form of biometrics, which is either you are going to give them your fingerprints and your identification, which is your facial image, or you would, in this case, usually, if you've done some form of biometrics, which is enrolling your fingerprints, then they will just ask for a facial image.
mm,
And
mm.
that's what
Okay.
a valid application is. And when you come down to paragraph I, it says that you should show that you have lived here continuously for a 20-year period. And so when it says continuously, it means that the period that you should have lived here for should be unbroken. So
Mm,
what can break my period of residence? Let's say that you've lived here since 1980 and you know that you've lived here for this period of time. But then they will say that if you, for any reason, were convicted of an offense and you were imprisoned for a period of at least 12 months, then it means that a period of 10 years must pass before your clock starts again. So if you went to prison in 1990, then a period of 10 years must pass before your clock starts again. So it means that in 2001, that's when your clock will start
mm,
to count again because they are discounting that period. And then if you were in prison for 4 years or more, your application would be refused anyway because you do not meet the suitability requirement. And then if for any reason you have traveled, so you have left the country and you were absent for a period of time, like 2 or 3 months, and um, that period of time exceeds 6 months, they would usually say that there has been a period of absence. And therefore, if you have been absent for a period of 6 months or more, then they are likely to say that you unfortunately do not meet the requirements and your clock has to start again from the time that you were absent. And so things like that can also be something that an applicant must look out for when they are making their application. When it comes to what proof you have to show that you have been resident for that period of 20 years. Most people will not have an account, like you said, and some people would have found ways and means to collect cash in hand, and they wouldn't have like a valid NI number and the rest of it. But most people that I know would have registered with a GP. So registration with a GP is brilliant. If you've registered with a GP, at least you can say that from this period of time, I was registered with a GP practice. And most GPs would have sent you letters. They would keep a record. They would try and obviously try and make you come to the surgery if you haven't been for some time. And then you have people who, for instance, have lived with other people. So people can verify and they can write letters of support to say that indeed they know this person. So if it's a family friend that you have lived with for the past 20 years, and that person can provide a letter of support to say, do you know what? I've been living with this lady for the past 18 years. This lady, I can say for sure, is somebody who is of good character. She basically has been supportive of me and my family during this period, and I know her very well. Those people can provide letters of support. The people within the household can provide letters of support. And you know that within our culture, a lot of us are Christians. So you will have people that attend churches. And so if you are a long-standing member in a church, then your church can also provide a letter of support to say that this person has been an active in our church, let's say for the past 20 years. And this person has been involved in other or various activities in the church. And if a letter can come from the church organization itself, that would also be useful. And you could use that as a point of reference when you're making the application. And then for people who, for one reason or the other, have had to have mobile phones, and we all know that we can't do without the mobile phones. So with mobile phones, for any reason whatsoever, you would have had a mobile phone and you would have to pay for mobile phone bills. So if you have a mobile phone and you've had to pay for the mobile phone bills, those kind of things can be used as well. So the bills, the itineraries, all of those things can be used as evidence that you've been resident in the UK for that period of time. And then there are various things that there are some people who, for one reason or the other, can provide statements from let's say credit organizations, because with credit cards and things like that, you may not necessarily have to provide any form of identification. So they are able to provide letters from credit card companies or credit companies to show that, do you know what, I've been resident in the UK. So those letters can also help. And there are some that may have also sought help from the council. And so for one reason or the other, they may be residing in council housing. And so those tenancy agreements can also form some sort of support in terms of documents that you can present in an application such as this. So anything that you can think of. It could be your tenancy agreement, it could be letters from credit companies, it could be anything whatsoever, letters of support, GP letters, anything whatsoever, even if you haven't worked or even if you haven't opened a valid account in the UK. Anything that can help prove that you have lived here for that continuous period can also help. And there are some people that have good record keepers and they have their passport right to go. So if you have your passport that you used when you came in even better, because at least there is proof that you entered the UK at the specified date in which you said you entered the UK. And if you haven't traveled whatsoever, your subsequent passports will show that you haven't traveled and you have continued to reside in the UK. So anything that you can provide. For some people, they even were able to go to school. So those school letters, those school reports, all of those things can help as well when making the application for leave to remain based on your private life. So yes, just a brief just of the kind of documents that you can also present when you are making such an application. Vicky, are you here with me? Okay, so
You
I think
can
we may have.
continue with your explanation. She will come back in a minute, yeah?
Okay,
You can continue with your explanation, yeah?
okay, thank you. So, as I was saying, in terms of the documents or the evidence that you would need, those things are various documents. So, regardless of the fact that maybe you haven't worked, regardless of the fact that maybe you haven't been able to open an account, those are the kind of documents that you should be able to gather. So, letters from the GP, letters from credit unions or
Okay.
credit companies, any form of letters from the council, even any bills that you may have, all of those things will help to show that you have resided in the UK a period of 20 years. And if you've attended a church for a long period of time as well, you can provide letters from or organizations. It could be charitable organizations that you've been involved in. Those organizations can also provide you letters of support. So anything that you can think of that you think will be useful in the application, definitely seek advice and then try and get as many of those evidences or those documents in support of your application. Yeah.
Lawyer Eunice, I've got one of our viewers sending this question. It's from John. He says, I have lived in the UK for 18 years. Whilst here, I met my partner who is a British citizen about 7 years ago. We have lived together for 7 years and even submitted an application as partners, which was refused. Which documents do I present when 20 years is up? I think you've answered that question already.
Yeah,
You've answered
so
it. Yeah.
that's what
Okay. Okay.
yeah,
All right. Then I'll move to the next question. Another unanimous viewer is asking, do you need to do the Life in UK test when applying?
So in this case, you don't have to do anything UK test because you will not be granted indefinite leave to remain. Basically, as I was saying, when you make an application based on private life, unfortunately, on that route, you cannot switch to the 5-year route. So you would stay on the 10-year route. It is only applicable to people who would be granted leave to remain on the
Leave it to
10-year
me.
route.
Okay.
So you
Okay.
would have to complete that 10-year route in order to apply for indefinite leave. So once
Okay.
you are able to apply for indefinite, then you do the Life in the UK test.
Okay.
Yeah.
All right. The next question. The next question is, I've lived here almost 20 years and do not have any documents. I registered with a GP surgery and I was unable to work or open an account. What do I do? Even though you did mention some of the other documents to state your continuous stay in the country for 20 years.
Yeah.
I think this
Yeah.
person is saying all he or she has got is just a GP surgery
Letter. Yeah.
Uh,
And in this case,
so
usually, in this case, usually most people will say, at least I registered with a GP when I first arrived in the UK. So once you write to the GP, usually the GPs will provide you with a long list, or should I say, a record of that person's medical history. And
exactly.
so that those things help because it proves that every year that this person has resided and has come for some sort of appointment. Like I was saying before, they need to see that the residence or the continuous residence that you've had in the UK is unbroken. So they want to make sure that every year that you say you have lived here, there's some sort of evidence or proof that you say you were here in the UK. And usually when you make such patients, depending on the number of times you went to see your GP, they can provide a whole list of the, should I say, appointments that you've had with them. And so if it's let's say every quarter that you went to see your GP, those records will be made. Or even if you requested for some medication or requested for something, those will be on the medical records. And then, like I was saying before, if you have people that you've lived with or resided with, those people can provide you with letters of support. So especially because they are third parties and they obviously can provide you with some sort of evidence that they have known you for a period of time. So let's say if you've lived here since the 1990s, they can say that, yes, I've known this as a person who is responsible. They helped me out. They even took care of my kids at one point in time. And I've known them since, let's say, 1995, and I continue to have a good relationship with them. And like I was saying before, if you are involved in a church, the church can also provide you with some letter or any charitable organization that you may be involved in, because I don't think anybody's an island. I think that when we are within the community, we tend to do things within the community as well. And so those organizations can provide you with letters of support to say that they know you and they can verify that you have lived here for that continuous that you say you have lived there for. For people who may not necessarily know how to go about it, when you come to see a lawyer, we can help you write letters to these various organizations, to these various third parties, so that we can collect as much documents or as many of those documents for you that we can use in support of the application. So, I mean, as much as possible, if you are thinking about making an application along those lines, then do seek advice and do seek help in terms of the kind of evidence and the kind of documents that you can present for that application. So yes, letters of support from people, from third-party organizations, charitable organizations, all those things can help. Yeah.
Okay. I think on that note, what I will also chip in and tell other people in this situation is, taking it very seriously when it comes to following routine appointments. People don't tend to visit their GPs. You see someone within 6 months, just once within 6 months. But definitely have to go in for a checkup. That, that kind of
and I think it's mostly to do with our black males as well. They don't want to go
exactly. I didn't want to mention it, but thank you. Exactly. There are others too who are not really involved with churches and things like that. So these things, when it comes to that point, will really help you a lot, because I've heard of stories whereby someone in such a situation only visited church once every 6 months. Now, when it got to this point, and she was advised by a solicitor to get a letter from her church, they told her they don't know her.
Mm.
You
And
see, because she.
yeah, that's one of the issues that can come up when you are literally, should I say, hand to mouth, and you're thinking,
Hand to
okay,
mouth, yeah.
I just need to do whatever I need to
And we
do
have
to
thing to
survive.
do. Yeah.
And
Yeah.
it's
Yeah.
unfortunate because you never know when you'll be able to rely on other people for the support that you need. So it's not
Right.
just about you. Like I was saying, you cannot be an island. You can't just stay on your own and just say that you will survive. At the end of the day, somebody else can also come to your aid. When you
It's
need that
true.
support, you will need that
Yeah.
person to help,
Yeah.
if it's writing a letter, or to say that, okay, I know this person has been helpful in A, B, and C, and so I can vouch for this person and say that this person has no absences whatsoever in the UK. They have lived here because I know that they are committed to this work, voluntary work that they do, and there's no way that this person would have traveled. So things like this, sometimes it doesn't come to mind so quickly, but when
Mind
you,
so quickly, yeah.
yeah, when you think about it, you say, oh yes, it's true. If I did this, if I did that, then and then you see that they're now starting to collect the evidence because now they've heard the advice. So they're like, okay, now
Advice,
I need
yes.
to do this, now I need to do that, and now I need to do this. And so it's good to get the advice early on so that people know
Yeah.
and are
Yeah.
aware
Yeah.
of what
Yeah.
to do before the time
Yeah.
is up.
Yeah.
Yeah.
Yeah. Yeah. On that note, ladies and gentlemen, I think we need a little break. We'll take an advert from BWS Solicitors, one of our sponsors for today's show, and we'll be right back. Please stay there. Oh, I think the advert is not ready yet. We'll have the advert come in when my producer is ready. Okay, Lawyer Eunice, let's go to the next question. Another person is asking, can I make the application a month before the 20 years is up?
In terms of the making application early, no. Because when you look at paragraph 276 ADEII, it says that you should show that you have lived there continuously for 20 years. So, unfortunately, if at the date of the application you haven't lived here continuously for 20 years, then they might as well say that, unfortunately, the evidence you present doesn't show that you have lived here for 20 years. And so, if the requirements are not met, then they also can refuse the application. And it's one of those things that people are thinking, but when I make the application, it's going to be with them for so and so period of time. And so whilst it's with them, my 20 years is going to be up anyway. So why wouldn't they consider that? But when you were making the application, you were saying that you meet the requirements, and that's why you were making the application. So if you do not meet the requirements at the day of the application, why then did you make the application? So if your application, you have to have reached the 20 years continuous residence. So you have to have lived here continuously for that 20-year period, because as I said, you will need that evidence to present to them to say that, yes, I have lived here for that 20-year period. I haven't lived here less than the 20 years. At least I spent 20 years. If you are saying that maybe you've lived here 22 years and you want to make the application, yes, that's fantastic. But you can't make the application earlier than the 20 years because you need to prove that you've lived here continuously for that 20-year period. And like I was saying, anything that will break that 20-year period will be things like being convicted of a criminal offense for a period of 4 years, or saying been absent for a period of 6 months from the UK, or even the fact that you would, it can be said that you may have committed an offense for which you received a prison sentence of, let's say, 12 months, and if 10 years hasn't passed from the time you received that prison sentence, then it means that the clock is going to start from the date in which the 10 years has passed before you can
Okay.
then think about making that 20-year leave application. So all these things have to be considered before the application is made, so that you know that you are making that application on a valid basis and it won't refuse just because you didn't think about these things before making the application. Yeah.
Oh, okay. Lawyer Eunice, how about someone who, upon entry into the country, um, came in with his name, and
Mm,
just along the line, he's known by another name. With
mm.
that changes, how can you prove the continuity to 20 years?
Okay. So usually if, let's say, you came with a different name and you are now known by let's say you're now known by John Smith. John Smith is
Okay.
one of those popular alias names.
Yeah, yeah.
So you're now known by John Smith, and you came with a different name when you were entering the UK. Usually, I know that most people, if they had come with a different name, would always not want to, should I say, disguise the fact that they came with a different name. And so they would say, oh, yes, I did come with a different name, but now I'm known as John Smith. In that case, if you're now using a different name and John Smith is what you have on your, should I say, GP surgery records, and John Smith
Mm-hmm.
is what you have, people know you by, even better, because then it shows that those people who have known you as John Smith can provide evidence to verify what you are saying. Usually, the reason why we ask for the passport, which has the date in which you entered, is so that we can prove to them that indeed you entered the UK on this said date. And then on this said date, you have counted 20 years and your 20 years leave to remain is up. If you don't have that passport, most people would have gone to get a police report. Police report will say that
To
you
prove that
cannot
you
find
lost your.
your,
Okay.
yeah, your passport,
Mm,
and so
mm,
therefore you are saying that this evidence of the police report is stating that at the time that you wanted your passport, you couldn't find it, and therefore you had to have a police report done to say that you've misplaced your passport. And then most people would use that and then swear an affidavit to renew a passport or to make a different passport application, because obviously they can't find the other one. And in terms of those kind of things, it does happen. So once you have a police report that states that you have misplaced that passport, it's good enough to obviously make records of that. But if you know you've used the name John Smith continuously, that will serve you well. But if
mm.
in at different points in times you have people who say, oh, I use John Smith, then I use the name that I came in with to do other things, and
Yes.
I registered with those other names,
Yes.
then you need to obviously have a change of name deed done to show that obviously you it is the same person. So I was
Exactly.
previously known as um Stephen, and now I'm known as John Smith. So Stephen and John Smith are both the same person, and I've used the name Stephen from, let's say, uh, the time I was born to one, and then I continued to use John Smith
Okay.
from 1992 onwards. So
Okay.
those sort of
Okay.
things would be necessary when also making the application, so that the
Mm,
caseworker is aware that obviously it's the same person. There is no harm in letting them know that you've used different names, because anybody's allowed to change their names at any
mm.
point in time. So it's
Okay.
not a big issue at all. Yeah.
Okay. All right. Brilliant. Brilliant. Right. Lawyer Lulinus, lastly, can such an application be refused, and what are the chances? Is it automatic so long as you're able to prove you've been in the country for 20 years? Is that an automatic?
I think most people think that
being given
it's
leave to
automatic.
remain.
Yeah. So most people think, oh, as long as I'm able to show that I was here for every year, then it's automatic that I should be granted leave to remain, or 30 months leave, which is 2.5 years. So in terms of what I was saying previously, if for any reason you have been convicted of an offense and you've been in prison for a period of 4 years, automatically your application will be refused. If you have a deportation order on you, your application will be refused. If for any reason you have been excluded from the UK because the government thinks that your conduct or your behavior is not suitable for the public good, you can be refused. If for any reason, let's say that you made an application and you were invited for interview and probably you did not
Didn't
respond,
show up.
and you did not give any
And
reasonable
also
excuse
to report.
to
When you
report
are
as
asked to
well.
report, you are scared that when you go in, you'll be taken away. So you decide you are not going.
So at least with the reporting, at least they know that you are here. But one thing that we should keep in mind is that they can refuse certain applications mandatory, and there's nothing you can do about it. So the mandatory refusals has to do with things like interviews or
Okay.
providing information or not giving them a medical should I say report or evidence that they
Report.
requested for, and you have basically not given them any reasonable excuse whatsoever. Those things, they are mandatory. They would literally look at the application, go back to their records, and once they find this, they would refuse it. But reporting is those things that they will look at and then they will say that they may. So with things like reporting, at least they are in a good standing, so they can say that yes, I wasn't able to go because I didn't receive the should I say the IS-19 to go and report. So in those cases, they have certain leeways. But in terms of things like interviews, they would usually write to your let's say your solicitor will write to
The
you
solicitor.
personally,
Yeah.
and then whilst your application is being submitted, they will invite you for an interview. So you cannot say that within the time that you made the application, you didn't receive any request for an interview and the like, because it was during that period that most of these things would have been given to you to obviously come to. So if you haven't provided the medical evidence, if you haven't attended the interview, because it was done during the time of your application, you don't have any excuse and they can refuse it. And then sometimes in a case where, for instance, you also have been absent and that period of absence is longer than, it's 6 months or more, then they can also say that you don't meet the requirements under paragraph 276 ADEIII, and therefore they are going to refuse the application. So in these instances, they can refuse the application because maybe you haven't met suitability requirements, or maybe you haven't fully shown that you have lived here continuously for that 20-year period, and there has been absences such as 6 months or more, and they refuse the application on those bases. If the evidence that you are providing hasn't got evidence to show that maybe you've been here every quarter, or let's say every 5 months or every 4 months, go back and see what other evidences that you can present. And that's why I was saying that if you're getting evidences from third parties such as churches or voluntary organizations or individuals know you, it's good that those individuals know you in a setting where they can say that, oh yes, I know this person because I see them on a weekly basis, or I know this person because I
Exactly.
see them on a
Exactly.
monthly basis. And those things help because then it can provide evidence for the monthly periods that we are looking for as well. So all of these things go on to support the application. And if for any reason a person is refused, they will be given a right of appeal because it's a human rights application. And
Okay.
so, and Section 82 of our Nationality, Immigration, Asylum Act, you would usually be given a right of appeal in terms of this application. And that would
Okay.
mean that you should be able to provide the evidence that we are looking for. But if it's a mandatory refusal, then those things you can't do anything about it unless the Secretary of State gives you some exceptional pardon and she says that, you know what, I know that usually I would not give you leave to remain, but there is an exception. So maybe
Exception.
because
Okay.
for some reason you have medical issues, you would not be able to receive treatment anywhere else than in the UK. On those bases, the Secretary of State will have to look at all the circumstances and see if she would still grant it to you and on an exceptional basis. So yeah, in
Okay.
the round, it all has to do with the evidence that you can provide and making sure that you as you're saying that you can provide it for the continuous period for which
Yeah.
you have chair, and you're not should I say you're not somebody who cannot make the application because for one reason or the other hasn't met their suitability requirements,
Okay.
as I've
All right.
mentioned.
Okay.
Yeah.
Right. I think our time is almost up. But I would like to chip in this. This is a concern, and this
Yeah.
viewer is just putting in a proposal. If you and your team can speak to the Home Office about this, it sounds funny, but
Mm.
it's a very it's something that is dear to this person's heart. He's saying that,
Yes.
if you are at the age of 45 and the Home Office is saying you should be in the country for 20 years to be
Mm.
able to apply for leave to remain based on private life. By the time he's
Mm.
given his leave to remain, I think
Mm.
he will be nearing his retirement. So how will he be able to be working and things like that?
And that's the thing that has
Is
really
there any way they could bring
astonished
it
a lot of
down
people.
less than 20 years?
And that's the thing, because a lot of people still call me and they're like, I know it used to be 14 years, so what happened? Why is it
Exactly.
moved from 14 years to 20 years? And I'm saying to myself, unfortunately, since 2012, when the coalition government came in, all of this changed. It was no longer 14 years indefinite leave to remain. It was now 20 years, 2.5 years leave to remain. And people are thinking, why would they introduce something like this? And like, as I said to you, because it's not an absolute right, so the government of the day has every right to interfere
I fear.
with it, because to them they don't see that it is in the public interest. So if you have lived here illegally for a period of time and they are saying to you that we must be strict on immigration and we must
So
create
is
an
there a form
adequate,
of punishment for being illegal for 20 years?
you can say that. You can say that because they are creating a
As for this
harsh
punishment,
and hostile environment. Yes, they are creating a harsh and hostile environment for people that have lived here illegally for this period of time. And before 2012, they used to think, well, if somebody can live here illegally and then straight away get indefinite leave to remain,
indefinite.
that is almost say encouraging this sort of behavior. And we
Okay.
don't want to be seen to
Okay.
encourage this sort of behavior. So we have to stamp our feet on it and
Okay.
no, you live here for this number of years and we will only grant you 2.5 years leave to remain. And if you are able to complete that 10-year route, then
Root.
yes, we would obviously grant you indefinite leave to remain. But if you have a spouse, or if like in the first question that was asked, if you are married to a British spouse and
Yeah.
you are granted leave to remain on the 10-year route, you can
You can
switch to the
switch.
5-year
Okay.
route because of that spouse. So
All right.
that's something somebody who is on the 10-year route can look
Okay.
forward to, because obviously they are married to a British spouse, and so therefore they can then switch to the 5-year route because of the fact that they have a partner in the UK who is British, and obviously they have lived together for 2 years or more. They can provide such evidence, and then provide evidence that they meet the financial requirements of 18,600. They can meet the English language test at level A2, and then their accommodation is also suitable. That way, that person can switch onto the 5-year route. But if you have no family life partner or a child who is British or who is settled, or the child who has lived here continuously for a 7-year period, then that means that unfortunately you will have to stay on that 10-year route until you are able to apply for settlement. Yeah.
All right. Okay. All right. So the viewer who was very concerned, I think there's nothing we can do. It's a form of punishment. It's rather unfortunate that you are nearing your 50s and you've been given the 10-year rule. By the time you are given, your leave to remain, you are getting retirement, and you just go on your retirement and relax.
Oh goodness me, it's harsh, but unfortunately we are in another man's land.
Exactly.
That person has
We
every
have to
right to
abide by
make
the
the rules.
rules. Yes.
Yes, they have every right to make
Yes.
whatever rules and regulations that suit them.
You're right. You're right. On that very interesting note, we've come to the end of the show. I must say thank you to all of you who sent your questions to us. Thank you to all those who stay tuned to us throughout the show. I would like to say thank you to my sponsors, Victon Estates, your number one property company. If you're looking for property to rent, you want to rent your property, sell your property, you want your property to be managed, look no other place than Victon Estates Limited. Their number is 0744-8619711, or go to their website www.victonestates.co.uk. The second sponsor we are very grateful for is Eagle Heights International School, your number one mass tuition center. I also like to say a thank you to a very lovely viewer on my show who surprised me with this lovely dress. She said it's Black History Month, so wanted me to go African a little bit. So thank you so much, Madam Grace, for this lovely outfit. I really appreciate it. It's making me look very different and beautiful. God bless you. And I also want to wish little Daniel a happy birthday. Dad and son all having their birthdays. Daniel is having his birthday today. Dad, I think a couple of days later. Wish them all a happy birthday. Wishing them long life and prosperity. Lawyer Eunice, can you give us your last words and any contact details for those who would like to contact you and seek further advice on how to apply on leave to remain based on private life?
Okay, so very quickly, just a quick update in terms of the application fee and immigration health surcharge. So currently, the application fee for any sort of leave to remain application is the same, but the UK government have now put into law that the immigration health surcharge should increase from £400 a year to £624 a year. This is for adults. So if you are making an application for leave to remain, you have to pay an application fee and the immigration health surcharge. And in this case, if you're an adult, you will have to pay a fee of £624 a year. And this fee is due to increase from the 27th of this month. So the 27th of October this year. So from the 27th, if you are making an application, the immigration health surcharge will no longer be £400 a year. If it's for a 2.5-year leave to remain, usually you'll be charged £1,000 for 2.5 years. But currently, and that is £1,000 plus the application fee. If by the 27th the fee increases, that means that you'll be paying £1,560 for the 2.5-year period that you'll be granted, including the application fee. They're saying that for children, this will be subsidized or this will be discounted. So that means that you'll be paying at least £470 a year for each child. And that means that it would be about £1,175 for each 2.5-year period that you'll be applying for. Currently, as we all know, you're making the application and you cannot afford the fees, you can put in a fee waiver application. Yes. And say that you do not have the funds. Provide your evidence of bank statements and pay. If you don't have pay slips, bank statements, evidence of accommodation, and other expenses that you may have in order to make that fee waiver application. And then they can have a look and assess the evidence that you have provided and grant you that fee waiver. Like I said, things are always changing in terms of our immigration. And so I just quickly wanted to put this out there so that people can also make a note of it.
But Lawyer Eunice, why is it that people are not given enough notice when there's increment? Like the one you're talking now, the NHS, what is the charge? And it's this month. Why are people not given a month, a year prior to the increment?
Increase. So this is something that they said during Boris Johnson's campaign before he became a prime minister.
Yes.
He said he was going to increase the immigration health surcharge. So this was something that was said during his campaign. And so yes, most people sort of knew that this person is coming to increase the immigration health surcharge.
Right, but we didn't know when.
Yes, we didn't know when. So it was earlier on during the year that they said they were going to increase it in October. So we made that announcement earlier on in the year that they said they were going to increase it in October. But we were not sure when in October that it was going to be increased. Yes, and so now, obviously, now that it has been signed into law, 21 days from when it was signed into law, which is Tuesday gone, which is the 6th of October, 21 days means that on the 27th, it would then be effective. And so therefore, from the 27th of October, people should have in mind that the immigration health surcharge will increase. Yeah.
Well noted. Okay. Yes. All right. Your details, please.
Yes. So, as you earlier on said, I am a solicitor at BWS Solicitors. We are located in Seven Sisters. Address is the 4th floor of Anna House. So 4th floor of Anna House, 214 to 218 High Road, which is the Tottenham High Road, and we're in London, and the postcode is N15 4NP. So N15 4NP. And our contact number is 0208 493 7340. So 0208 493 7340. That's our office number, and we're open from Monday to Fridays from 9:30 to 6 p.m. And my contact number, which is out of office hours, is 075 35 81 3910. So 075 35 81 3910. Thank you so much, Vicky. Have a wonderful
Thank you,
week.
Lawyer Eunice. And thank you so much as well, Lawyer Eunice. My regards to the family, and also my regards to the BWF family. So, we'll meet again next week, Saturday. Stay blessed and stay safe.
You too.
Okay. All right, ladies and gentlemen, there you are. We are, sadly coming to the end of the program, because I know a lot of people would like us to go on and on and on, because they are really being educated, impacted. With this program we do have every Saturday morning, with our immigration status. But trust me, we are back again next Saturday at 12 noon, and we will also touch on another very popular topic. I'm not going to say that now, but we will definitely come back and discuss a very popular topic. Till then, take good care of yourself, observe social distancing, cover your nose and mouth, and wash your hands properly from time to time. Stay safe, and God bless. Bye.
At BWF Solicitors, we take pride in our client service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station, for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.